good morning, everyone in the UK. Good afternoon, everyone in Dubai, as appropriate wherever you happen to be in the world. Thank you very much indeed for joining. I'm sure everyone has been absolutely inundated with budget webinars and briefings and so on and so on. So really appreciate you joining us for our debrief. Those of you who have been on the webinars, the debriefs and so on that we've done before know that we like it to be a bit more interactive. It's not necessarily just us talking at you for an hour. As we're going along, please do ask questions. If you could drop them in the chat box, if you do have questions, I will keep an eye on that. If they are sort of appropriate to be raised at that moment, then I will do so. It might be, if I don't sort of pick up your question, it might just be because we're going to cover it in another section, but I'll make sure that we cover them all. And then there'll be time as well for sort of a more general discussion and Q&A. So for those of you who don't know me, the lucky ones, my name's James. I am a managing partner at Sanctoras, firm of tax advisors and accountants, based in Dubai now, previously in the UK, and split my time. And on the call, we have also got my colleagues, Rich and Charlie. Rich, I don't know if you just want to do a brief intro first.
Yeah, morning everyone, afternoon, again as appropriate. I'm Rich Thomson-Curtis. I lead up our UK practice. So you will hear me a fair bit, unfortunately, for everyone for the first section of this.
Yep, and hi all, I'm Charlie. For those who don't know me, I am in UAE, similar to James. I specialise in the corporate and business tax advisory. So you probably won't hear too much from my side, but I'll chip in as and when needed.
Brilliant. So in that case, I'm going to put myself on mute. I'm going to watch the chat box. As I say, please throw your questions in as we go. And in the meantime, I'm going to hand over to Rich.
Thanks, James. So, I mean, everyone's read all the press, all the opinion pieces, all the budget documents, hopefully. We'll know that it was a fairly chunky one for technical tax reasons. It wasn't particularly headline grabbing in certain areas, and we'll come on to why that was in a second. I think that's mainly due to how the Labour Party manifesto was written, of course, before the election in July. My view is there was somewhat hamstrung by what was included in the manifesto as to what they could do. Obviously, that then brought its own issues, as then arguments all over the internet of what a working person was. James now claims he's not a working person, and that's why he's not answering his emails. But we'll go from there, and I'll start writing my P45 now. So in terms of headlines, and we'll dip into these as we go along. IHT featured a fair bit and continues to feature in the news with regards to reliefs and pensions. CGT was possibly the main headline grabber, and was certainly the main headline grabber leading into the budget, and was the subject of the most speculation as to where CGT rates would go. And bottom right hand corner there, we've got the changes to non-doms, which we knew were coming in some form or another, since being announced by Jeremy Hunt back in March. And then employer NICs, again, we've heard a fair bit of in the last couple of weeks. And then a nice little bonus at the end there to HMRC of having more staff made available to them so we can pester them. They claim it's so they can collect more tax. I hope it's more staff to answer the phone. So moving on, very quick update as to headline updates. Income tax, again, Labour Party manifesto made it quite clear that they wouldn't increase the rate of income tax, of national insurance or employee national insurance, or VAT, value added tax. So income tax rates thresholds, no change. We're still at our 20, 40, 45 or 8 point something, 32 point something, 39 point something for dividends. In a little bit of a bonus, income tax threshold, so that's the personal allowance, and the threshold at the between the basic rate and the higher rate and upper rate will increase after April 2028. They'll have been frozen for probably a decade by that point. Employee NICs, again, remain unchanged since being reduced in the spring. And then CGT, where we saw quite a fair bit of activity. 24% for the higher rate is nowhere near where it was potentially rumoured going to. I mean, I read everything from 21 to 39%. 24%, therefore, marrying the rates up with that for residential property feels like a reasonable middle ground, and certainly, again, is still lower than the top rate was back in the early 2010s, I think it was, when we were up at 28%. Lower rate increased from 10 to 18, and that was introduced with immediate effect. Now, there were some anti-forestalling provisions included in the draft legislation that we've seen, by and large, to prevent certain levels of planning in advance of the budget. So we'd seen previously about unconditional contracts and kind of when conditions are satisfied. But the one that seems to have been picked up this morning is on potential disqualifying or disapplying share for share exchange provisions to be able to claim business asset disposal relief on any transactions that appear to have happened this year. Just needs a bit more detail on that legislation, but again, it's just something to keep an eye on. It's not surprising, given where business asset disposal relief is going, that certain provisions have been included, but that, if drafted as it certainly first reads, that feels quite punchy, let's put it that way. Business asset disposal relief, I did not expect it to survive, but it did. Rate currently 10%, will increase towards the lower rate of 18%, but gradually over 2 years. So we've got 10% for the rest of this year for disposals where BADR applies, 14% next year, and then marrying up with a lower rate of 18% from April 26. Investors relief, again, has been around for about a decade now. I've never seen it used. The lifetime allowance for that was left at 10 million when BADR was reduced to 1 million. Didn't really understand why that was the case, but that investors relief lifetime limit has been dropped now to 1 million as well, and that's 1 million of gains. The other one that was in the press and manifesto, carried interest. So payments made to certain private equity executives, currently taxed at 28%. There is an argument as to what carried interest represents, whether it's a performance fee or whether it's an investment management fee or whether it's a true capital gain. They seem to have gone somewhere in the middle. So the rate will increase from 28 to 32% on 6 April 24, and then we'll move to the income tax regime. and then be subject to a 72.5% multiplier. So 100 of carry becomes 72.5 that's taxable at up to 45% plus NICs, that results in a total effective tax rate of, it's a shade over 34%. Quick ones on SDLT. So for anyone that's kind of holding property in their own names, purchase of additional dwellings, the surcharge for that, it was 50-50, to be honest, as to whether they'd increase that surcharge or the surcharge for non-UK non-UK residents purchasing property. It was 50-50 as to which one would go up. They've chosen the surcharge for purchase of additional dwellings 3 to 5% from yesterday. And within that, any corporate entities purchasing residential property valued above half a million, that was at flat rate of 15%, now becomes 17%. And then there were holidays for first-time buyers where they got a higher 0% band, and just a higher 0% band of SDLT anyway. They were due to end 31 March 25 and won't be extended. And then finally, again, it was snuck in, I think it was about page 151, stamp duty on shares. Government consulted earlier in the year on a trading platform for private business shares, potentially as an alternative route to raising capital than a full IPO. It's been suggested that any trades within that platform will not attract stamp duty. Again, stamp duty was potentially rumoured to be on the block, but again has survived. Whether this is a way to potentially get rid of it at some point in the future, wait to see on that one.
Sorry, just one point very quickly. Everyone who has had their coffee will have just spotted on the carried interest. Charges are from 30% from 2025, and then within income tax from 26. Time travel was not one of the announcements.
Yep.
So 6th of April 25, income from 2026.
IHT, nil rate band residential, nil rate band again has been at 325 for give or take a decade now anyway, and will remain as such until 2030. Potentially then brings more estates into the scope of IHT at some point. From 6 April 27, any unspent pension balances, and this is quite a significant change, death benefits will be brought into the taxable estate and be subject to IHT up to 40%. Now, this is bringing pensions back towards their intention of being a retirement vehicle rather than an inheritance tax vehicle. And it brings them broadly in line with the rules as they were pre-2015 pension changes. Bigger changes around IHT, around APR and BPR. So going forward from 2025, I think this is, isn't it, James? The first million of qualifying assets under APR and BPR will attract relief at 100%. Anything thereafter will get 50% relief, so effective 20% tax rate. There's been a lot today in the press about farms, and certain farmers, Jeremy Clarkson in particular, has been particularly vocal about the impact of this change on IHT on farms. It's basic. The way I see it is it's been introduced to tackle those people that aren't perhaps quote unquote genuine farmers, but are buying farmland for the purpose of IHT planning.
There's an interesting point on that someone brought up, which is, given that farmland has been seen as a good investment for IHT purposes specifically, and then it's tenanted, it is what sort of artificial impact that might actually have had on land values anyway. So if you remove at least a chunk of inheritance tax relief on farmland, what will that do in terms of land values more broadly, and therefore what the impact will be on the number of estates that actually fall within the scope of inheritance tax anyway. And although it's $1 million of relief, and that's $1 million combined between any of your agricultural assets and your qualifying business assets, although it's $1 million of relief, you can quite easily see, I think, a reasonably straightforward bit of planning where you end up with $2 million effectively of relief. So take a typical scenario of married couple, where typically everything on first death would be left to the surviving spouse. No inheritance tax because transfers between spouses are exempt. Then on second death, left to children, you get $1 million of relief. If instead, if on first death you leave $1 million of farmland, business assets, whatever it is, to children on which you claim relief, and the balance of your estate to surviving spouse then leaves another $1 million of land or business assets to children, then effectively between two deaths, you've got $2 million of relief rather than just your $1 million. Also,
which is an extension of the old double dip planning when you use business assets and trusts.
Yeah, and so it's I suppose a potentially sort of practical point is, again, around trusts, is reviewing wills and what your provisions are around wills. So currently, what in the event of someone's death, what would be left either to children or what might be left, for example, into a discretionary trust on death under your will, subject to other comments on how this impacts with trusts. So it might be an opportunity to review your wills or review your clients' wills as well. And just very quickly, if I can, just while we're on sort of the IHT point, the question from Ryan around pensions and whether income tax would still apply. So the point here is that there's a cutoff at age 75 where your beneficiaries, if you pass on your pension, would be liable to income tax when drawing your pension down. What I think we currently can see, and I'm not aware, I'm happy to be corrected, but I'm not aware that there's anything specific ruling this out at the minute, is that you could be in a situation, if you have a more substantial pension pot, where you have 40% inheritance tax on death to leave your pension to your children, for example, and then they are liable to income tax on drawing it down, and it gets you to an effective tax rate. I think it's just over 67% on the value of your pension. So again, it's exactly as Rich said, it's very much moving it back to it's a vehicle designed for your retirement and for you to live on in your retirement, which poses the obvious question of how long is your retirement going to be? And that's where we defer to the financial planners amongst you on whether to how to draw down your pension and what that might look like in practice. I know that there have been, and again, this sort of applies for those of you who are outside the UK as well, particularly, transferring UK pensions to a CUROPS, a non-UK pension scheme. That there was previously an exclusion whereby you could do that without a charge if you were transferring your UK pension to a CUROPS in the EEA or Gibraltar. You now can't do that, or you won't be able to do that. There'll be a 25% charge to transfer as well. So that's one to bear in mind for those of you with a UK pension, but who may be already outside the UK. I know there are a few on the call.
Touched on trusts. I'll jump down a point. Obviously, this affects a lot of planning that's gone on previously with BPR shares going into trust. So this is likely to be significantly affecting, potentially significantly limiting this availability of planning going forward. We're expecting a technical note early next year to figure out what on earth's going on with that. And then the last thing on BPR is shares that were unlisted but listed on certain qualifying stock exchanges. So AIM in the UK, I think there was some in the US and elsewhere, but are classed for tax purposes being unlisted. Previously attracted 100% relief. So that's kind of you get specific portfolios, particularly Octopus, for instance, one of them that were quite prevalent in doing this. Now the relief again limited to 50%, so an effective tax rate of 20%, and there is no £1 million band for that. So any AIM shares effectively at 20% IHT. Then other quick announcements. Obviously, VAT on school fee was already announced back in July. Triple lock and pension maintained, so that's going up by 4.1% from April. National living wage increased again from April 25, with a view was mentioned about having a single minimum wage for all over 18s rather than currently where there's one for 18 to 20 and 21 up. And then fuel duty has continued to be frozen, and that 5p per litre will be kept. Now we go to the fun stuff. So announced by Jeremy Hunt back in March this year of a significant change in the taxation of non-UK domiciled individuals. This foreign income and gain regime, FIG regime, whether anyone comes up with a better name, please let us know, will be introduced from April 2025. And this is now a 4-year scheme. No charge to access the 4-year scheme, where an individual can realise and bring in to the UK unlimited income and gains which arise overseas in that year. And that's quite a significant change from what we have currently, where remittance basis, it protects your overseas income and gains, but if you bring them into the UK, you bring them into the charge of UK tax. For those individuals who are not able to benefit from this FIG regime, so for those that have already been in the UK for longer than 4 years, I think that the limit is, I would tell this more, is the 22-23 tax year. So if individuals have been in the UK since before then, they won't be able to access the new FIG regime. They'll have this temporary repatriation facility, which there's certain conditions. For example, you need to have claimed the remittance basis and had income and gains protected by the remittance basis before, to remit those income and gains into the UK at 12% for 2 years. And in a change from what Jeremy Hunt had previously announced, there's going to be a 3rd year where gains can be remitted at 15% flat tax rate, income and gains, sorry. CGT rebasing for any post-April 25 sales is going to be permitted at April 2017, which I mean is a significant time gap, I think. it's probably since April 17 is probably where a lot of asset appreciation has happened since. So that's an interesting. I think that was originally slated at being 2019. So it's been moved back a couple of years. What impact that will have, potentially limited, but again, it's an asset by asset basis as assets are sold. Overseas work day relief, again, applied in a few circumstances, but it's going to be modified. So it's now going to be, again, 4 years long to match the 4-year FIG scheme, and kind of just modified slightly. In the biggest change, existing structures, so trusts, companies that are overseas, there will be no grandfathering of current legislation to existing structures, such that basically any structure that exists or will exist will be within these rules to a varying extent, depending on the long-term residence of the relevant individual. And that's that point at the bottom of in what, again, is the biggest change that we see. So if a non-UK domiciled individual establishes a trust with non-UK situs assets, that trust will be an excluded property settlement insofar as it does not hold UK situs assets. And that will remain kind of ad infinitum. This will now change such that the excluded property status of the trust can change with whether the status of the settlor as time goes on. So if the settlor is not a long-term resident of the UK, come on to that in a second, then the trust will be an excluded property trust as we currently understand them to be. When the settlor becomes a long-term resident, the trust will become a relevant property trust and thus within UK IHT, subject to 10-year charges, subject to exit charges. Now, if the individual subsequently becomes not a long-term resident again, so leaves the UK, in a similar to how it works now with property ceasing to be relevant property, there will be deemed to be an exit charge again, another it's up to 6%, sorry, rather than 60.
Sorry to interrupt, Rich. Just very quickly, just clarify the point a couple of people have mentioned. This specific section here that Rich is going through now, this relates to the current domicile regime, or rather the current non-dom regime as it currently stands. So essentially people who are from outside the UK, if you like. So this is separate from the new rules, which Rich will come on to momentarily. These bits will be relevant to those people who have previously claimed to be non-domiciled and are living in the UK or are moving to the UK for the first time, by and large. Now, some of these elements will also become relevant for people coming to the UK under the new rules as well. But that's just to make clear that a lot of this, so repatriation of funds, for example, and rebasing and so on, that relates to the existing population of non-doms in the main. So for the new residence-based rules, they will come separately. So just for those living outside the UK, bear in mind that these rules probably still won't apply in the majority of cases, but the new rules, they will. Sorry, Rich.
Yeah. And the other thing to mention, to access the FIG regime, the 4-year scheme requires 10 years of consecutive non-UK able to access the scheme. So if an individual has not been in the UK for 10 years, then arrives in the UK, argument's sake, 6 April 2025, they will be able to access the scheme. And in a change from how the domicile rules are currently, if an individual has a UK domicile of origin, for instance, if they go and lose that, acquire a domicile of choice elsewhere, and come back to the UK under current rules, that UK domicile revives as soon as they regain residence. This will change slightly such that what we would consider a UK domiciled individual can leave for 10 years, come back, and then be able to access this scheme. There's no carve out for kind of existing UK persons or previous UK persons. And then obviously with the changes to domicile and inheritance tax goes hand in hand, given how inheritance tax is written, that UK domiciled individuals are subject to IHT on their worldwide assets, non-domiciled individuals only on any UK citus assets. So the IHT changes were originally slated to be commencing from April 2026. However, have been accelerated to 2025 at the same time as the new FIG regime. And again, this brings IHT to a residence-based regime rather than one based on facts in the round, based on case law, that can be a bit grey, a bit woolly, and very much subject to opinion or views. This is very much a yes or no. Someone either is a long-term resident of the UK or they're not. And this all is based now on the statutory residence test of if an individual has been UK resident under the statutory residence test for at least 10 of the previous 20 tax years before a charge arises, so a death, for instance, they will be considered to be a long-term resident of the UK and therefore within the scope of UK IHT on their worldwide assets. If you're not a long-term resident, again, kind of consistent with the current domicile rules, you would only be subject to UK IHT on any UK citus assets. And it's quite clear in the documents that that is not changing, or that is not planned to change. And then, which was long subject to speculation, there is going to be a tail on how one can lose their long-term resident status. And that turns out that it will be between 3 and 10 years and will require somewhere between 3 and 10 years of non-UK residence to break your link to the UK and then being not subject to UK IHT and worldwide assets. However, that depends on circumstances, including how long you've been here in the first place. These from the budget documents, so they were released about 1 o'clock-ish on, so 2 o'clock-ish on Wednesday, just on the new domicile changes, new IHT. I think the draft legislation, the technical notes, run to something close to 150 pages. It is quite wordy. There are a lot of examples and case studies. But unlike the current system we have, actually it's probably provides quite a lot of clarity. There's less opinion involved. There's less of a needing a view of whether one is domiciled in the UK or not. It is very much, as I say, fact-based. For individuals, actually, it's quite clear. So for someone coming to the UK for the first time, it's very clear as to what their limits are before, again, they are within the scope of UK IHT. And again, for people leaving, and in particular for people leaving, where it becomes a bit of a guessing game, I guess, or a very subjective view on when one acquired a domicile of choice elsewhere thus breaking UK domicile. This again is very factual of you will be long-term resident, long-term resident, long-term resident, and then 6th of April of 1 year, you will cease being long-term resident. So it actually ends up providing these new rules a lot of clarity for advisors and individuals on what people need to or to not do to be inside or outside of these rules. There you go, you've had enough of me. I will go over to Charlie now for the brief run-throughs of what's gone on for businesses.
Yeah, you'll be back soon because it's fairly quick. Yes, as expected, there were no changes to corporate tax in the budget, and they've said that they'd keep it the rate it is till the end of their government. They have released a corporate tax roadmap, which has basically outlined some changes they'll be making to transfer pricing, specifically ones with multi. They might be scrapping UK to UK transfer pricing, which is a bit strange, but outlining further details on jurisdictions to multinational companies. So people that, for example, a UAE entity might charge a consulting fee to their UK company. They will be doing more details on that, which could help. The next one, would be employer NIC. So there's a few good examples on this, especially on LinkedIn, that outlines the significant rise in costs for businesses, although the government seem to think it won't be. Well, they said they'd raise loads of taxes for it, but they said it can be afforded by a lot of businesses, which, to be honest, I disagree with, but that's each to their own. And the employment allowance will go from 5,000 to 10,500. And then apart from that, to be honest, there isn't much else. Annual allowances for capital allowances will stay the same. And that's really it, to be honest. The duties on tobacco and alcohol will just kind of stay in line with recent policies. And there'll be reforming on business rates as well, which more to be announced on that in due course. But yeah, apart from that, there isn't much to report on the business front.
And I think that makes sense because the one in March, I think, focused a bit more, and last autumn focused a little more on businesses. So
Yeah,
again, with given how the manifesto was written, the discussions or the discussion pieces from Rachel Reeves, both pre and post election, about wanting certainty for businesses, it feels like it's about in line with what we thought we were going to get.
Yeah, agreed. Yes, that's fairly quick from me.
I think as well, it
Excellent.
probably means that she's left herself a little bit of room for the future as well, bearing in mind that we've only had this government for a very, very short period of time so far. It feels that potentially she's left herself some more wiggle room, despite things like committing to the rate of corporate tax and so on. There are certainly other things in there that can be played around with. So it will be interesting to see whether things change more on a business and corporate front in due course. So that's probably one that we'll watch out for.
My wife's firm's view was that she had a number to get to and got to it and then stopped. I think that's their unofficial view.
Just and for those who own companies that then own other companies. So this is to Martin's point. There is it relates to sort of chargeability to corporation tax. So normally, if a company makes a disposal of an asset, that gain is also subject to corporation tax. There are specific provisions that if one company owns shares in another, that gain can be exempt under what's called the substantial shareholdings exemption rules. Just to answer Martin's point, as far as I'm aware, nothing has changed on that. So things like taxation of dividends, which are in the majority of cases, dividends received by a company are tax-free in the UK, which can be very, very tax efficient, very beneficial. Being able to sell subsidiary companies. So again, as part of sort of looking at wider structuring and what you might do as part of your wider estate, thinking about things like the higher rate of capital gains tax, for example, the answer might not always be, well, I'll just leave the UK, because that has lots of practical considerations as well. There may be consideration around things like how do you structure from a corporate perspective so that you can still benefit from the reliefs that have been retained.
And then finally, not going to bore people too much over HMRC. They are allegedly going to be recruiting more staff. They're going to modernise the systems. There's some streamlined, simplified reporting for both advisors and for preparers of tax returns with various data. And then finally, and probably the most relevant to, I think, on late payment interests, which currently sits at 2.5% above base, will now become 4% above base. So currently, I believe that's it. So I've had enough of me waffling on. James, over to you.
Sorry, I'm not sure if it might have just broken up a little at the end there, Rich, or whether that was just at my end.
No, that was, sorry.
That's also for me as well.
In any case, never mind. So some significant changes that will affect some people. Lots of little changes around the edges that won't affect too many people. All in all, I think a little bit of a sort of slightly unusual budget in that sense. Some things we were expecting and some things we knew, some things that were perhaps quite pleasant surprises, like the rate of capital gains tax. Please do, Rich, if you just want to carry on sharing your screen, possibly, just so that we've got the slides up. But if anyone has questions, please do either drop them in the comment box, or now please feel free to unmute yourself. Just to address a couple that have come in. So, for example, Elizabeth, around the concept of domicile, making it easier for those leaving the UK to fall outside the scope of UK inheritance tax. So the current position today is if you are domiciled in the UK, you are subject to UK inheritance tax, even if you live abroad. And being domiciled in the UK is very, very subjective. It essentially means, where is your real home? Where's your true home? Where are you from? Where were your parents from? It looks at every facet of your life. And it's very, very difficult to lose your UK domicile status. it's not a tax concept specifically, it's a general legal concept. So it applies very, very broadly. Which means that even if you have been living outside the UK for 5, 10, 20, 30 years, it doesn't guarantee that you're not subject to UK inheritance tax. For example, it's historically been very, very difficult to prove that you have lost your UK domicile, you've cut all ties to the UK, you never plan to go back, and you plan to stay in, for example, Dubai forever, and the case law says, live out your days. That's been exceptionally difficult because it's so subjective. With the new rules, it gives a huge amount of certainty, but it also opens the door to a group of people who would not really have had this opportunity before to fall outside the scope of inheritance tax. So if you think currently you've got to move to a country, you can't sort of leave the UK and dot yourself around and spend some time here and there and what have you, you have to be fixed somewhere. Under the new rules from April, as long as you're non-resident for non-UK resident for 10 years, you could spend that time in Dubai, Malaysia, sometime in the US, sometime in South Africa, wherever you like. You don't have to be fixed in one place. And I am, and I think some other people are, quite surprised that there don't seem to be any provisions in the draft legislation for this, that would prevent somebody born in the UK from equally benefiting from these rules. So where you think that the big talk about non-doms in the press, not always used accurately either, but the big talk has been the wealthy foreigners from outside the UK living in the country and not paying their tax. What I think they've actually done with this measure is make it far easier for UK nationals to leave the UK and not pay inheritance tax in the future. What the rules also mean, however, is you leave the UK for 10 years. If you then go back after that, all of those rules that Rich went through before about 4 years of not paying tax on your income and gains, being able to remit funds to the UK won't be quite so relevant. But all of those rules will also apply to you as though you're moving to the UK for the first time. And you'll also then still have a 10-year period before you become subject to inheritance tax again. So you can see what it achieves for the non-doms that they were trying to do away with the non-dom regime. But I think it's very interesting that they've gone so far in the way that it will benefit so many UK individuals as well, particularly knowing how many people are leaving and have left the UK. Kevin, on your point on, again, just carrying on the theme of inheritance tax. I said that people who are domiciled in the UK are subject to inheritance tax under the current rules. As with everything tax related, there is always a apart from or a but. That there are some treaties, particularly India is a common one that comes up, and Pakistan, that effectively mean you can be treated as domiciled in the UK, but not pay UK inheritance tax if you are also domiciled in India. So it's been very, very favorable for Indian domiciled clients for a very, very long time. Since 1956, the Indian treaty came in. And Kev, your question is, will that protection still exist in the new legislation, or with the new legislation. So we've got rid of the concept of domicile for tax purposes, and now it's based on residence. I'm not, as far as I'm aware, nothing specific has been said about this, but my interpretation of the treaty is that yes, it should still apply, so that if you are subject to UK inheritance tax because you're a long-term UK resident, but you are also domiciled in India, then I think the treaty still applies, and so Indian domiciled clients will be protected. And the reason
am I still here?
So all I heard was a snippet of Rich saying what I thought was lies.
Am I still here?
Yes.
Apology, I've had internet troubles. Yeah, there was a point in the technical briefing note that said there are 10, I think it is, treaties in which IHT is included, and they expect that those will not be affected by the change from domicile, quote unquote, to long-term resident.
Yeah, and I mean if we look at when they brought in the deemed domicile rules in the UK, which was if you lived in the UK for 15 years, you'd be treated for tax purposes as though you were domiciled in the UK. And before that, there were other rules for inheritance tax as well. You still benefited from the protection of the treaty. Primarily, the treaty refers to being domiciled in a particular country. And as I said, domicile is a much broader concept than just for tax purposes. Certainly in UK law, it is relevant for succession and heirship. It's relevant for family law proceedings. It's relevant for which courts can hear certain cases, so England and Wales or Scotland. So yes, it seems that protection is still going to be relevant. So for those of you with Indian clients who are also in the UK or otherwise exposed to UK inheritance tax on worldwide assets, worth revisiting that with them and reviewing their planning. Some other questions. So Dustin, regarding recent changes affecting non-DOMS private clients, significant fallout from new legislation, and the government decides to shift its approach, how quickly could such changes be made and implemented? Or does this signal an end to the UK's attractiveness for high net worth individuals? Very good question. Changes could be made and implemented pretty much immediately in theory. If you look at the capital gains tax increase, for example, that was effective immediately from the day of the budget, including with some what's called anti-forestalling. Some people would say is effectively retrospective for sort of ease of how to describe it, which means if you did something before the budget, you could still be caught by the new rules. So I mean, in theory, changes could be made and implemented very, very quickly, either for the better or for the worse, depending which side of the fence you're on. And I think that there is probably an element of waiting to see what behavioral impacts the budget has. As always, they shouldn't, but they absolutely do. Leaks are made to the press in advance of the budget, very often to try and gauge public reaction or media interest or whatever it might be, and that's used in part to inform decision making. So the point around waiting to see how people react and what people do before taking more action, I think is a relevant consideration. I think on the basis that things, I think, could have gone a lot further in some ways, particularly regarding capital gains tax, for example, or in some ways on the other side of the coin, seem to be quite beneficial, like the ability for Brits to leave the UK for 10 years and fall outside the normal tax rules. I think that it's one to carry on watching. Is it an end to being an attractive place for high net worth individuals? Charlie and Rich, if you have views, or indeed anyone else on the call, please do. We like them to be interactive. So please share your thoughts as well. We've got people from lots of different industries on the call as well. I think that there are at least two things. There's actual tax policy, and there's actually how people are going to be taxed. And then there's sentiment. And a lot of the reason that we're finding people are leaving the UK is not necessarily solely or even primarily because of potentially significantly higher taxes, but because of what can be seen as perhaps a generally slightly more negative attitude towards, quote unquote, the wealthy. And we've seen this reignited again in a slightly different form with how do you define a working person. So it's an interesting point. I think London will always be a centre of interest for people. If you can structure your affairs so that you're not receiving income on which you're going to be taxed on an ongoing basis. In the UK, it's a very high rate, and you know that you've got 10 years at least before you're going to be subject to UK inheritance tax. And of course, we won't now have the remittance basis charges where you had to pay a charge every year after you'd been in the UK for 7 years to benefit from this favourable regime. I think it will still attract people and in some ways might have a slightly more incentivizing effect in some ways.
No, I think I agree with that. And we've seen it, that with the rhetoric around non-doms and loopholes for it in particular, it's not been the quote unquote non-doms who have been leaving the UK anyway. I mean, they have, but we've seen far more of UK domiciled individuals, UK business owners, UK workers, or not workers, that are disappearing. And taxes are a factor, but I look out my window, I see it's raining, and James looks out of his window and it's 30 odd degrees. That's ultimately going to be a massive driver as well.
Yeah. And the same in, not quite in reverse, but sort of on the same theme. A lot has been made, I think, in the press generally of everyone's going to leave, everyone's going to leave, everyone's going to leave. And I don't think you can underestimate the practical difficulties, but also the emotional upheaval of moving your kids out of school, them having to make new friends. What do you do about managing your business if you've got one? What if you have elderly parents? What do you do about wider family? There's a lot more to it than everyone's just going to leave, especially given that there are rules as well that say if you only leave for a relatively short period of time, generally sort of 6 tax years, 5 calendar years, and then go back to the UK, you're going to be taxed on your return anyway. So it's a long-term commitment that requires a lot of upheaval. So those who are already very internationally mobile are already internationally mobile. They are, by definition, more able to move. And those who are not already internationally mobile, I think there are the real practical considerations that need to be borne in mind.
I'll take Ryan's question quickly. Business property relief. Sorry, Ryan, I'm adding the P back into BPR because I don't know why it was removed and I don't like it. But BPR, business relief, business property relief, that is potentially, I think that's something that we're going to have to wait for the technical note early next year of whether we can start whether business relief qualifying assets into trust without entry charges before the rules, and whether they'll incur periodic charges. I suspect it may end up with a £1 million band covering APR and BPR assets, split by the number of trusts established by the settlor. So you'd end up with something similar to how the standard rate band used to work, the CGT allowance for trust that's kind of split between trust. I suspect that's where it might end up, but it's a typical tax advisor's answer of it depends, I think.
There was certainly specific comment about trusts set up on the same day by the same settlor, and that allowance being split. But I would agree. I would assume there will be some sort of division in there.
So for clients now, James, who are holding BR qualifying shares, would it not be a good move to start considering moving them up to trust now ahead of time, or could that, in theory, not work? Or
yeah, it's a very good point, Brian, and I suppose for other people's benefit as well, when we talk about shares that qualify for business relief, business property relief, we're talking about shares in trading companies, for example. So your own trading business that you've set up is a typical example, and various other assets as well. And what a lot of planning has previously involved is transferring those shares into a trust while you still own shares, as in before you sell them and you have cash. Transfer the shares, benefit from inheritance tax relief, so that you don't pay inheritance tax on transferring them into a trust, and then there's no inheritance tax later on when you pass away. It is sort of the very oversimplified version. So I think, Ryan, to summarize your question, is essentially, if you're going to be restricted to £1 million of relief from April, should people be transferring their shares into trust now? And I think that there are pros and cons to both options, very much in the same way that there are now, in that one of the big things you've got to consider is that for this type of planning to be effective, you, the person transferring your shares, have to accept that you're not going to be able to benefit from those shares. So if you put shares into a trust and you later sell those shares for £1 million, £5 million, £10 million, doesn't really matter, that money's locked away. You cannot benefit from that money during your lifetime. Your children can once they're over 18, but you can't, your spouse can't, your civil partner can't, your children, while they're under 18, can't. So I think the same sort of practical considerations apply in terms of whether things should be moved now or later. Rich, I'm not sure if you have a view on that, but I would think that while there is still effectively an unlimited exemption for business property relief rather than being capped at £1 million, it's certainly worth considering based on the values that we're talking about.
I agree. I think I'd agree, because then even if the rules come out in January, say, or the draft legislation comes out in January, you'd be within the first however 10 years, then be able to reverse it relatively deeply.
Yeah. I think one potential situation where I would need to think it through, but where it might be worth waiting, is if you've got someone who's already been outside the UK for 10 years or approaching 10 years, so that they would be a not a long-term UK resident under the new rules, if what they are putting into trust are non-UK shares. So I think that's going to be a very limited number of people. So long-term non-residents holding non-UK shares that qualify for business property relief. That's potentially, I think, worth it. But otherwise, I think perhaps looking at it now while we've got an unlimited exemption is certainly sensible.
Okay, thank you.
No worries. Carly, in the comments as well, Carly is so for everything I said about it's not that easy to up sticks and leave the UK, Carly's a brilliant example of one of our lovely clients who has done it very, very successfully and is now, I can reliably attest, thoroughly enjoying life outside the UK. It is difficult, but it is doable, right? You think people do it all the time. And again, as much as I say about schooling and family and so on, which are all important considerations, if for your lifestyle as well, you want to move outside the UK, it is eminently achievable. And it's a lot of the work that we're doing consistently is people leaving the UK.
I think that's a bigger reason for people leaving at the moment, more of a lifestyle than tax. Tax obviously comes into it, it's a big part, but I think the lifestyle, especially moving to a place like here, Dubai, the weather, the many branches, the countless other things. I think that's more of a factor nowadays.
Dubai is one that has obviously, received a lot of attention in the press, and not always the most positive attention. Fair to say that we all know that there is a certain perception, and I think that those on the call who are here or spend time here will probably attest that it is not for everyone the sort of the streets being paved with gold that is portrayed on the news. But as well, we're taking an example there of somewhere with ostensibly no personal tax, although taxes are obviously levied in other forms, and now we also have corporate tax. But there's always been a bit of a competition, for example, between London and New York as to where people might move to if they are from outside the UK or the US. And London historically had a bit of an advantage over New York when we still had we do now, but when we really had the very favourable non-dom rules. In 2017, when changes were made, we saw a bit of levelling up, and I suspect that they will still be big powerhouses. Also bearing in mind that moving doesn't necessarily mean upping and moving to a zero tax jurisdiction. Places like Italy, Greece, Spain, Portugal all have favourable regimes for new arrivals into those countries. So you've got what people might think of as tax havens, Switzerland, arguably, Monaco, Dubai, and so on. Cyprus, Christina, thank you very much. If anyone wants to know about Cyprus, Christina Elmacall is a good person to speak to as well. There are places far closer to home than 3,500 miles away, in the middle of the sand. Does anyone have any comments, questions, observations, scenarios that you would like to run through? Should say this is not your one and only opportunity. We are very, very happy to answer questions and sort of act as a bit of a sounding board. If for those of you who are thinking of, well, what should I do now as an individual or as a family or as a business owner, there's still going to be quite a lot to digest and things to think through. And there's a bit of time before April as well. Bear in mind, it's not that much time. There is some time, but it's not indefinite, and things can take longer than you might anticipate. So it's worth thinking about things much sooner rather than later. And for the other advisors on the call, we've got people in accounting, banking, immigration, structuring, financial advice, legal. We've got the network of people, and I hope I'm okay in speaking for everyone in this call in saying that from an advisor's perspective, we're all very happy to answer questions, share thoughts, run through scenarios, because we're all still also going through what does this mean in practice. It's going to evolve over time, both in terms of what we've currently just received from the Chancellor and in the coming years as well. So I think my takeaway from it would be, we've got some really good ground now to know where we stand. I think most people will need to sort of assess their tax affairs before April, even if it's just a quick, just checking that there's nothing to change. On the legal side, speak to your lawyer, or we can put you in touch on wills and reviewing what you've already got, particularly if you have business assets, agricultural assets, if you're moving around different places. From a tax perspective, again, have a look at what your plans are, what your movements are likely to be, and what assets you have. And as I say, April will come around quite quickly. So take the opportunity now to have a review, get a plan together, and get things in order. We are happy to share the slide deck. We have a slightly more detailed one as well. There's a recording of this webinar that I'm happy to send around as well. So unless there is anything else from Charlie or Rich or anybody else on the call, I think that's us. Thank you very, very much indeed, everyone, for joining. Really appreciate you taking the time out of the day. You know where we are if you need help, and we will speak to a lot of you very, very soon.